Car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis, Wright, and host David Lamb.
Hello and welcome into the attorneys. Thank you so much for joining us on this Sunday evening. For the next half hour, we've got a panel of experts assembled to answer questions that we believe you have, specifically dealing with a topic that I'm certain you'll find of interest. The way it works throughout the program, you'll see ways you can join the conversation at the bottom of your screen. Also, a reminder, there are attorneys standing by right now, so great opportunity to get some free legal advice. I urge you to take advantage of those opportunities. And leading our conversation, as he does often, Josh Wright from the firm Hollis.
Good to see you.
Good to see you, sir.
We actually do answer calls.
Someone from church asked me, I wanted to see if there really was an attorney standing by, and they called, and by golly, I think they said at 11 o'clock at night, someone answered the phone.
Thousands of calls, texts, and emails every year are answered by the firm on various topics. And a lot of times, the topic is not relevant to the show we're doing,
right?
But we still have lawyers that can field, kind of lead, guide, and direct people through the legal process. And if we don't know it, we'll get you in touch with somebody that does.
That's the way it works.
Justin Taylor's with us tonight. Justin is a lawyer that does criminal work, does some estate planning. We're going to tackle criminal law tonight. We've done some shows on criminal law, but it's become more and more important in Alabama, given the fact that we've had our overcrowding in our criminal system. Mm-hmm. We have 46,000 citizens in Alabama, 46,000 citizens that are in and incarcerated in a jail in Alabama. About 14,000 DUIs per year in Alabama. We're going to talk a lot about that, how the laws have changed, David, and what you do if you get yourself in trouble from a criminal perspective, and the importance of getting a criminal attorney involved.
Sounds good.
So Justin, first of all, thank you so much for being on. We really appreciate it.
Thank y'all for having me.
Absolutely. Let's kind of jump into this, because I think there's confusion generally when people think of criminal law, and they're used to hearing civil issues. How do those two things kind of jihad together?
Yeah, so civil law is really, John Doe, Jane Doe sue each other. And criminal law, you usually have a state actor, a city actor, municipal court, state court. Someone is actually trying to punish you for a crime that you have committed. And with civil law, you're generally trying to recover some type of damages, some money award.
And David, one of the things that we have to explain in our civil trials when we go in front of a jury is the difference between the standard they may hear on TV in a criminal context, which is beyond a reasonable doubt, which is a very high standard, and the civil standard, which is the preponderance of evidence, which is 51%. So in a civil context, what we argue is if you have the scales of justice and you fill those scales up with evidence on each side for the plaintiff and for the defendant, you have to tip those scales ever so slightly, and the person who tips those scales, either the plaintiff or the defendant, is successful in the lawsuit. In a criminal context, and Justin, I'll just let you kind of explain it, how do you explain to juries the concept of beyond a reasonable doubt? Because it's a pretty high standard.
It is. I generally go through the burden of proof, just kind of explaining it, and I usually end with, it takes clear and convincing evidence to take a child from a mother or father. And then we have a higher standard or burden of proof than that level. So it kind of reiterates that, hey, you have to be not 100% certain, but you can't have a reasonable doubt in your mind.
Well, what are the steps in general that you go through in the criminal process? What does that process look like?
So normally we start with an arrest. That's when the officer makes the arrest either by warrant or by probable cause to arrest. Second step is booking, where they're taken to the jail. They're able to determine whether or not they're going to be able to bond out. Occasionally you're not able to bond out because you have a probation hold or something of that nature. With the bonding process, normally what we see is you can either pay a cash bond for the full amount that they set, and then that money will be returned to you at the end of your case, or you can use a bondsman. A bondsman usually charges about 10% to 15%, and that money, once you pay that to the bondsman, that is actually gone. So once you bond out and use a bondsman, you don't get a refund on that money, or you can put up property to bond out. The next step is normally a first call in district court if it's a felony or a misdemeanor, and then after that they have a preliminary hearing, And at the preliminary hearing, the court will determine whether or not there's there's enough evidence to proceed. And at that point, if there's enough evidence, or if the defendant decides to waive their preliminary hearing, the case will go to the grand jury. The grand jury will listen to the evidence and determine whether an indictment will be issued. If an indictment is issued, which is a true bill, they will come back and there will be an arraignment date. And after the arraignment date, or at the arraignment date, the judge will provide you with what you're being charged with. And then after the arraignment, you move into either a pretrial docket to where you might be able to work your case out if that's what you want. And then if you're not able to work it out, you move into the jury trial where the state has to prove beyond a reasonable doubt that you're guilty.
Let's dissect that a little bit. When in that process do you believe it's best to get a lawyer involved on your side? And it may relate to the type of charge that you've got, where there are some charges where not having a lawyer is appropriate, but some charges where you must. And I don't know, I've never talked to you about that, but give us kind of your thoughts on that.
Yeah, so the sooner you get a lawyer, the better off you're going to be. And the reason I say that is because police officers, law enforcement in general, they have ploys, they have tricks that they use occasionally to get you to elicit statements from you. So if you talk to an attorney beforehand, they're going to tell you, hey, you don't need to talk to law enforcement, but as soon as you can hire an attorney, you're going to be better off, because your bond may be set really high and you may spend if you have a $100,000 bond, $10,000 to get bonded out. Well, if you have an attorney before then, they may be able to get your bond reduced, so you save you a little money that way too. So,
are there circumstances where the grand jury does not indict?
There are, but that is very few and far between. And normally, what we say is a prosecutor could indict a ham sandwich if they wanted to. They could. They get in there. They, they're able to present evidence. The defense is not in there, and then they can get an indictment.
I think we're getting ready to go to commercial break. When we come back, one of the things I do want to talk about, which is important, is the difference between a misdemeanor and a felony, and how that can, I think we both can talk about it, how it can implicate kind of your life and what happens to you moving forward for jobs and those types of things. Because I think the difference between those two crimes is significant from a criminal context.
Good deal. We'll take a break. We step aside right here as we do so. A reminder, we'd love to have you join the conversation. Call, text, the information right there on your screen. Also a reminder, an attorney standing by would love to speak with you. More of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
Welcome back into The Attorneys. Thank you so much for joining us tonight. Love the feedback that we get and the questions that we get from you folks who are calling, the attorneys that are standing by right now. An excellent opportunity for you, so be sure and take advantage of that. Josh?
David, when we went to break, I wanted to break down this concept of misdemeanor versus felony, because it does, it will impact you kind of on a moving forward basis. Let's break that down if we can. Explain kind of the difference between a misdemeanor and also a felony, and maybe the implication it can have in your life.
Yeah, so a misdemeanor is a less serious offense. Crimes like possession of marijuana, second degree, which is a smaller amount of marijuana, a DUI is a misdemeanor. A misdemeanor carries a punishment range of 0 days in jail up to a year, okay? And a felony actually carries a year and a day up to life without the possibility of parole, or in capital cases, the death penalty. So a felony is a much more serious offense and can have long-lasting implications on job possibilities because a felony is crimes like rape, burglary, robbery, those types of things. And when employers look at that, they often are hesitant to hire someone who is a felon.
David, a couple things, if we can, for a moment, look at how it just operates in everyday life. A conviction for a felony can have an impact on whether or not you can own a gun, whether you can vote. If you're in a civil case, let's assume, for example, you had a felony in the past and you're involved in a civil case because, let's say, you were involved in a traffic accident. When you're testifying in that traffic accident case, there can be certain assumptions that you explain to the jury that if a person has a felony, you can perceive, you can assume that person is less credible and they're not telling the truth as to how that traffic accident happened. And so having a lawyer involved when you have the potential of a felony on your record is super important to make sure that, I mean, you may ultimately be convicted, right, but having a lawyer on your side can protect you, and you want to be led through the path of the criminal courts with somebody that knows what they're doing to try and protect you as best they can. Sometimes the advice from that individual lawyer may be, look, this is a felony that we're going to end up having to plead guilty to, right, but there are other options too for individuals who have limited records, those that had not been involved in felonies in the past. There are ways that you can work with your lawyer to try and help yourself as best you can, because once you get that felony on your record, it can have a major impact on your life.
Yeah, a good question we have here. If I'm charged with a crime in the state of Alabama, is there a way to get it off my record?
There is, if you haven't been convicted. Currently, the way the law is set up is if you have a conviction on your record, if you've actually been convicted of the crime, there's no way to get it expunged. But if you've been charged with the crime and had it dismissed with prejudice or without prejudice, if you've completed a diversion program like drug court, you can actually have that conviction or have that arrest expunged off your record. So a lot of times what we've seen in the past is these employers, they'll have these questions on their job applications, you know, have you ever been arrested? Well, if you've been arrested, you have to say yes, but now with the way the expungement law works is we can actually have that arrest taken off your record. That record is then sealed and you're able to answer no on that question.
And I know we get a lot of questions every time we talk about expungement. In fact, we've done entire shows on the concept of expungement, drug court. We've done an entire show on that. So I know we're going to get a lot of questions on this issue. If you were convicted of something, expungement's not your option, is it?
That's correct.
All right, so it's got to be a dismissal, a no bill, or some type of diversion program that you use through the court system that you successfully completed to be able to go through the expungement process.
That's correct.
Okay. And the expungement process itself, it doesn't sound to me, because we've done shows on it before, Justin, doesn't sound like a process you want to go through on your own. Don't you want to hire a lawyer to be able to get that done?
You do, because you have to file a petition with the court that you were charged in. So if it's in municipal court, you have to file it with the city. If it's a state case, you have to file it with the state. And it has to go through circuit court if it was a misdemeanor or felony brought by the state, and then it has to go through the municipal court if it was just a misdemeanor charged by the city.
Let's talk for a minute, because I know we get a lot of questions whenever we do criminal shows on what responsibilities you have when you are pulled over from a police officer, what information you have to provide, how you can be respectful but still be able to maintain your own rights, those types of things. Can you walk us through that just a little bit, because I think it's an important topic.
Yeah, so you have to provide biographical data. You have to give them your name, your date of birth, your address, that type of thing. But anything else you don't have to answer. And you can be respectful in declining to answer. But it's always our philosophy to, tell our clients, don't give them, don't answer those questions. If they ask to search your vehicle, don't give them consent to search, because if they don't have probable cause to search your vehicle, then, they wouldn't be asking.
And that's something you see quite a bit. I mean, a lot of the escalated moments that happen that we see on the news, on television, starts with a traffic stop and then ends with a terrible result in some respect, one way or the other, either for the police officer or for the prospective criminal.
That goes right into the question that we got from a viewer. Whenever you're approached by a police officer, are you required to answer the questions posed by the officer? And what if the officer asks for consent to search my car or my house? Must I allow them to do so?
No, you do not. And again, I always advise never give consent, because truthfully, anytime you allow an officer in to search your car, your home, that just gives them a little more leeway in finding evidence to maybe use against you for some crime.
Talk with me a little bit too about Miranda rights and how that works. We get a lot of calls every single time we do a criminal show, and there's nothing wrong with this, is people asking legitimate questions about Miranda rights, and they want to know, I wasn't read my Miranda rights, or my son was not read his Miranda rights. Shouldn't he be able to get off on that technicality? And the answer generally is no, but explain that to us just a little bit.
Yeah, so the general answer is no. For instance, for Miranda rights to be required, you have to be in custodial or in custody, and it has to be a custodial interrogation. That means that you have to be under arrest, you don't have the right to leave, and they're asking you questions related to the crime, or really just asking you any questions, but you have to be in custody. And the relief that you can obtain if your Miranda rights were violated is not a dismissal, it's just the suppression of those statements.
Gotcha. So if you make statements, very likely without your Miranda rights, once you're in a custodial circumstance, you may be able to suppress that.
Correct.
Let's talk when we get back about DUIs. 14,000 arrests in the state every year for DUIs. I want to talk about that and how the law has changed, not just how the law has changed, how the penalties have also changed.
All right, we'll step aside. This is our final break of the evening, so a great opportunity to remind you to join the conversation. Would love to have you do so. Also, you can find the firm of Hollis Wright on both Facebook as well as Twitter. Search the term Hollis Wright, find them on Facebook. Great opportunity to find out what's coming up on the shows. Just like that page, and on Twitter, you can follow at hollis-wright.com. You'll find it there. Stay tuned. More of The Attorneys coming right up.
I'm Carter Clay with the law firm of Hollis Wright. When someone whose unreasonable conduct causes an injury to someone else, the law says that person is negligent. So it seems the injured person should receive some type of damages, right? Not always so in Alabama. In tonight's Legal 411, we answer the question, what is contributory negligence and comparative fault? Alabama is one of only 4 states in the nation to withhold damages based on contributory negligence, meaning if you are at fault, even just a little, you cannot be allowed any damages in a case. For example, in a case where a defendant may be 99% at fault for hurting you, if you are found to be 1% at fault, Alabama law says you get nothing. 4 states, Virginia, North Carolina, Maryland, and Alabama, plus the District of Columbia, are the only places in the country where a defendant can completely avoid paying if the injured person is even 1% at fault. This is very different from comparative fault, the measure used in 46 states. There are 2 versions of this system, but both essentially allow money damages based on the percentages. For example, if the injured person was 20% at fault for causing an accident, then the recovery for medical bills and wages is reduced by 20%. Numerous studies across the country show that people who live in comparative fault states believe this system of justice is more fair. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will always respond to every question you send in. That's our pledge and promise to you.
Welcome back into the attorneys, the final segment here. So as I've said a couple of times already, attorneys are standing by right now to take your calls. So just a few minutes remaining for that to take place. So if you have a question, the opportunity to get some great free legal advice from a respected group of attorneys. So go ahead and give them a call. Josh?
Well, I mean, you said respected group of attorneys. I don't know. Is that,
I'm here with two of them.
Is that an oxymoron, or is that a real deal?
You guys are the top of the heap.
When we were going to break, I mentioned DUIs, and that's always a hot topic. With 14,000 DUIs across our state yearly, and about 10,000 of those are actual convictions, there's a high conviction rate for DUIs. Let's talk a little bit about that if we can, Justin. And I know the laws have changed over the last couple of years, and the penalties have gotten more strict, have they not?
They have. In 2014, they imposed an ignition interlock law, which increased the penalty. So for a first conviction within 5 years, the penalties are a lot the same as they have been in the past, except for now we have a minimum $600 fine and a maximum $2,100 fine. But if you refuse to provide a breath sample on the breathalyzer, or you have children in the car, or if someone else is injured in the accident other than you, they can actually impose an ignition interlock for 2 years. So you'll have your license suspended for 90 days, and then after you get your license back, you have to do the interlock.
We get this question every time we do this. We get this question. We have it once again. So let's just go ahead and deal with it. You probably know this because I think we do this every time. But they want to know: am I required to perform a roadside sobriety test or undergo a breathalyzer if requested to do so by the police? One of the most popular questions we get.
No question.
You do not have to. You do not have to provide the field sobriety test or perform the field sobriety test. You do not have to provide a breath sample. And what I always tell my clients is, I always tell them that when the prosecutor presents their case, it's like three legs to a stool. And if we can knock out a leg, that stool's less sturdy. If we can knock out 2 legs, then the stool's probably going to fall over. So what I always tell my clients is, you're better off not providing that breath sample and that field sobriety test. But there are some issues you have to deal with your driver's license if you do not provide that breath sample.
Yeah, and let's talk through that. What is the issue if you don't provide the breath sample or the field sobriety test? Is your license guaranteed to be suspended for a period?
So with the field sobriety test, it's not going to be suspended if you don't do those. But if you do not provide a breath sample, your license is going to be suspended, and it's called an administrative suspension for 90 days for failing to provide that breath sample.
What happens if you're in the unfortunate circumstance where you've gotten a DUI 1 and then you get a second DUI? What do the penalties continue to increase and kind of exponentially up?
They do, and it's within that 5-year time frame. So if you get a second conviction within that 5-year time frame, your minimum fine goes up to $1,100, and then your maximum fine will go up to $5,100. And then you also have to deal with, there's a mandatory minimum jail sentence of 5 days. Now you can elect to do community service in lieu of that 5 days, but the community service comes out to about 30 days or 240 hours of total community service.
We get a question related to an out-of-state DUI and then getting an in-state DUI and how those things work together. If you get a DUI, for example, in Mississippi, and then 2 years later you get one in Alabama, are both of those on your record, meaning that it becomes a DUI 2 the second time?
Yes, that's correct. They're going to count that. Most states are part of the interstate compact to where they're going to count that conviction as a conviction and use that for sentencing enhancement purposes.
You know, one thing that's interesting about your bio is that you're a former police officer. Every time, I've never been a police officer or an attorney, but every time I'm advised, you know, folks say, don't do the field sobriety test, don't answer those questions, don't let them search your car. I wonder, okay, well, that's going to be kind of uncomfortable. As a police officer and as an attorney, you've seen both sides. Is that not a little awkward whenever you're told, nah, I don't want to take that test, I don't want you to search the car?
It is, and I can tell you that even to this day, after being a police officer, when I see those blue lights behind me, I get a little nervous myself. So I can understand that someone who's not been in that field, not an attorney, they will get nervous. But from a police officer standpoint, you know, that's your right. You have that right to do that. You know, they're not going to abuse you or yell at you or anything like that. You know, you can exert that right.
What's your opinion, just given your history on body video, that's become kind of a big popular topic right now, and there are a lot of proponents for making sure that all city police officers in our state and across the country have body cameras. What's your thought on that, given that you've seen both sides?
I think it's great, and most of my friends who are still in law enforcement, they like it too, because it protects not only the individual who is being confronted by law enforcement, but it protects the law enforcement officer from false accusations. So I think it's beneficial for both parties.
Yeah, and I tend to think that's a good idea too. A lot of the crime that we see that hits the media that turns into hate crime, I'm not really taking a position as to whether or not it is. A lot of that could be locked down with video to show what happened, and audio to show what happened and what the circumstances were, because a lot of times context is everything. We can't forget that police officers are also put in terrible situations sometimes, in life or death situations on a daily basis, but specifically in these moments, having body cameras and audio would probably help in a lot of those.
And with what we've seen, especially the last few years, that's going to be a debate and a discussion much more so. Just a couple of minutes remaining, but want to give both of you an opportunity. Just a final thought from you. What do you want to leave our viewers with? And Justin, you go first, please, sir.
Yeah, I think it's important to be respectful if you're confronted with law enforcement, but at the same time, you have these rights. These rights are given to you. They're undeniable. Go ahead, don't be afraid to exert those rights. And at the first opportunity, if you are charged with a crime, it's very important that you contact an attorney and get that advice that may save your future.
Right.
David, I'd close with this. 46,000 inmates across our state, 14,000 DUIs, 10,000 of those are convicted each year. This is a significant issue, whether we like to talk about it or not, across our viewing audience. It's why we do criminal shows, to be able to at least explain to people that there is help out there if you found yourself in this circumstance, or if you have a child that's found themselves in this circumstance. And so, we bring people like Justin on because they can lead, guide, and direct people through that process, and they can do it in a cost-effective way where it's not going to financially ruin you, but also give you good legal assistance and help in those moments. Sometimes those moments end up being a conviction. Sometimes those moments, because you've got counsel involved, maybe a plea down or a dismissal of a claim. So having counsel involved is super important.
Yeah, great conversation
Thanks
tonight, gentlemen. Appreciate it. Thank you for being with us. Thank you for being with us as well. As we wrap things up here, we leave you with how you can get in touch with the firm of Hollis Wright. Also, for just a few more minutes, you have opportunity to speak with an attorney standing by live right now, waiting just for your call. So take advantage of that opportunity. As always, thank you so much for joining us. We look for you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.